Ready, start. As apparent from the record, the appellant accused and the complainant had been colleagues for the past 5 years, and it is somewhere during this time that their relationship progressed. We notice once again that the appellant accused had initiated legal processes against the complainant much prior to the subject FIR being lodged. These included a so-called notice issued by the employer regarding her continued acrimonious behavior against the appellant, with the ultimatum that should she not respond to the notice with the requisite clarification, she would be relieved of her employment. It is only thereafter that the subject FIR was lodged. Further, the same was lodged 4 months after the alleged incident of forced sexual intercourse with the complainant. If the description of the offense is taken at face value, right at the first instance, the complainant was not willing and was persuaded to engage in relations on the assurance of eventual marriage between the parties. When she inquired as to when the same would take place a few days later, allegedly the appellant refused and asked her to marry someone else. That would be the first occasion when, having realized that she had been taken advantage of, the complainant should have taken the requisite action. Even if that was not done so, the fact that the subject FIR was only lodged after the issuance of so-called notice, which obviously has large real world implications insofar as the complainant is concerned, leaves open a gaping possibility that the same was lodged as an afterthought and was a vehicle for vengeance for the impending consequences described above. At this stage, we would like to observe something important. Whenever an accused comes before the court invoking either the inherent powers under section 482 of the Code of Criminal Procedure or extraordinary jurisdiction under Article 226 of the Constitution to get the FIR or the criminal proceedings quashed, essentially on the ground that such proceedings are manifestly frivolous or vexatious, are instituted with the ulterior motive for wreaking vengeance, then in such circumstances the court owes a duty to look into the FIR with care and a little more closely. We say so because once the complainant decides to proceed against the accused with an ulterior motive for wreaking personal vengeance, etc., then he would ensure that the FIR/complaint is very well drafted with all the necessary pleadings. The complainant would ensure that the averments made in the FIR/complaint are such that they disclose the necessary ingredients to constitute the alleged offense. Therefore, it will not be just enough for the court to look into the averments made in the FIR/complaint alone for the purpose of ascertaining whether the necessary ingredients to constitute the alleged offense are disclosed or not. In frivolous or vexatious proceedings, the court owes a duty to look into many other attending circumstances emerging from the record of the case over and above the averments and if need be, with due care and circumspection, try to read in between the lines.